Thank you, Professor. I'll move on to a different issue. I've got some questions that arise from the report to the Minister that was prepared by TEQSA on the higher education sector response to the issue of sexual assault and sexual harassment. But let me step back from that to start with and say, in its work, it's a touch philosophical, does TEQSA apply the principle that all people should be equal before the law?
Yes.
Yes.
I shouldn't be too controversial, right? And maybe another general principle. Does TEQSA operate according to the principle underpinning our legal system that says that the more serious the consequences of a decision, the higher the standard of evidence and proof there should be before that decision is made?
Well, I think that's part of our act, isn't it, in terms of acting proportionately and necessarily and according to risk, yes.
Proportionality, beautiful. Lawyers would call it the Brigham-Shaw standard or something like that. But because, this is an area, it's really fraught, and I acknowledge it's difficult. You want to make sure, everyone wants to make sure that people who experience terrible actions like sexual assault are treated respectfully and with care and pastorally, and they get justice. But at the same time, that report, in the way it deals with, at 4.3, procedures for responding, says absolutely nothing about the proper process for dealing with someone against whom an allegation is made. Given that an adverse disciplinary finding by a university from a sexual assault allegation under, student conduct codes and so forth, has the effect in many cases of meaning a student wastes the money they've spent trying to get a degree, wastes the time they've invested in their degree so far, can't enter the profession for which they've trained, has a destroyed reputation, and all of this has implications for the criminal law where they may be having to also deal with the matter. A whole lot of penalties a court could never impose. I'd suggest it's really very important that these things are proven to a high standard and on the basis of reliable evidence. Would you agree with that proposition?
Yes.
Okay. When I look at the procedures that are in place at universities for handling situations like this, most of them provide, quite fairly, notice to the accused that an allegation has been made against them and an option to reply to it. So I guess I can give them a tick on that measure. But for example, if you look at the University of Sydney student complaints procedures, it doesn't provide for access to the evidence that's been provided against a person, only access to the allegation. There's no power to call evidence in your own defence, no requirement for evidence against you to be sworn, no effort to ensure the reliability of evidence in the way that we would if something was done before a court. And there's no right to legal representation, even though the effect of an adverse finding can be the loss of all of the things I outlined a moment ago. And so, in addition to that, you've got no presumption of innocence, no right of appeal, and allegations, and this is probably the worst part, only need to satisfy uni administrators on the balance of probabilities. Does TEQSA regard this framework, which is reflected in the policies of most Australian universities, as an appropriate balancing of the real and serious needs of complainants with the fundamental rights to be treated equally of an accused?
As you said, this is a very complicated matter.
Agreed. But does TEQSA regard that complete imbalance as acceptable?
Well, we haven't actually discussed this at the Commission in those terms, and it would be inappropriate, I think, for me to give an off-the-cuff response at the moment.
You've produced a report on it. TEQSA has produced a report on this very subject in which the issue of the rights of a person against whom a complaint is made did not even get a mention. Mm-hmm. So, TEQSA is engaging with this admittedly difficult subject. It shouldn't be a matter that's off the cuff.
I'd have to remind myself of the contents of the report.
Look, just in relation to the report, that report was how we saw things at the time. We are, as you've heard from some of the earlier responses we've made, Senator, we are still very much actively engaged in this, trying to identify good and best practice within providers. And like all of our publications, we are very consultative and very open, and we accept comments and contributions. So if there are processes which are believed to be deeply flawed in the way that you suggest, then we're open to that. We don't rerun the disciplinary procedures of the universities of the providers themselves. We seek to determine whether or not those processes are working in a way which is fair and which, achieve their intention.
Well, I'd be delighted to work with you to try and make sure that there are processes in place that are working fairly for everybody in universities.
I would just make one final point in relation
Sure.
to that we also try to distinguish between those matters that might be dealt with by an internal disciplinary process and those matters which are matters to go before a criminal court, and not for either jurisdiction to step across the other.
Quite right. Look, thank you for your candour on that. I look forward to working with you on it, and I thank the Chair for the time.
Thank you.